private practice. He was also the corporation counsel for the District of Columbia, well known in Democratic circles. By all accounts, he's going to be very forceful in making this presentation. He does have high credibility in legal circles here in Washington, and that's why the president brought him in when he did bring him in. And Chuck Ruff, with that credibility that he's developed over 2 to 3 decades in Washington, will try to score some points.
Okay, well, thanks. We'll be back to you.
And Bob Franken is up on Capitol Hill for us. Bob, as the White House defense team makes its case, what are the Republican managers going to be doing?
The Republican managers who met just a short while ago before they went over are in fact going to be very visible. They decided that they want to be there as the reality checkers as the White House lays out its case. They'll use every opportunity they can, the 13 House managers, to go to the cameras and to rebut whatever it is we've just heard from the White House. So they're not going to be sitting in the background as, for the most part, the president's attorneys did. Of course, they're trying to put together their witness list, although we have a pretty clear idea who is and is not going to be on the witness list. It's going to be the boilerplate group of perhaps 5 that they'll submit, but there's still a lot of tactical discussion going on. They want to try and make sure that the White House doesn't recover from any of the points that they scored.
We mentioned earlier a letter urging a boycott, a letter written by a couple of House Republicans. Does that idea seem to be catching fire at all?
Not among Republicans. The Democrats would love it, we're told. If, in fact, the Republicans did that, they would love the chance to jump on them. But for the most part, the Republican position has been expressed by the likes of George Gekas and Jim Sensenbrenner that they will respect the office of the presidency and go to the floor. There are a few Republicans who are suddenly developing the flu, but for the most part, Republicans realize, they say, that any sort of real boycott would be very, very bad tactically.
Jeff Greenfield, I want to come over to you now and talk a little bit about public opinion, because this day seems in many ways tailor-made for public opinion. Our most recent poll that we've taken shows a very strong sense that the trial should end, that the president should not be thrown out, and that people asked, 81% of them said they'd rate this overall presidency a success.
Yeah, and you know, even that number isn't, to me, the most striking, because Henry Hyde last week described the president as having had a successful presidency. But you know the benchmark number? How do you think the things are going well or badly? 70%
I'm sorry, we have to interrupt. I believe that the Chief Justice has just called things to order on the floor of the Senate.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against William Jefferson Clinton, President of the United States.
The Majority Leader is recognized.
Mr. Chief Justice, it is my understanding that the White House presentation today will last approximately 2.5 hours, maybe a little more, maybe a little less. But I would therefore suggest that a short recess be taken in approximately an hour, around 2 o'clock, to allow the Chief Justice and all members to take a brief break. And I remind all senators that they would remain standing at their desk each time the Chief Justice enters and departs the chamber. If there's a need for another break, I will kind of keep an eye on the White House counsel to see if they need a break, and we'll act accordingly. Of course, I remind senators again tonight, if you would be in the chamber at 8:35 so that we can proceed to the joint session. I thank my colleagues for their attention. I yield the floor, Mr. Chief Justice, and I believe we're ready to begin.
If there's no objection, the Journal of Proceedings of the trial are approved to date. Pursuant to the provisions of Senate Rule 16, the counsel for the President have 24 hours to make the presentation of their case. The Senate will now hear you. The Chair recognizes Mr. Counsel Ruff to begin the presentation of the case for the President.
Mr. Chief Justice, members of the Senate, distinguished managers. William Jefferson Clinton is not guilty of the charges that have been preferred against him. He did not commit perjury. He did not obstruct justice. He must not be removed from office. Now, merely to say those words brings into sharp relief the fact that I and my colleagues are here today in this great chamber defending the President of the United States. For only the second time in our nation's history, the Senate is convened to try the President of the United States on articles of impeachment. There is no one who does not feel the weight of this moment. Nonetheless, our role as lawyers, as much as it would be in any other forum, we will not be able to match the eloquence of the 13 managers who spoke to you last week. We will try, however, to respond to the charges levied against the President as directly and candidly as possible, and to present his defense as clearly and as cogently as we are able. We seek on his behalf no more than we know you will give us: a fair opportunity to be heard, a fair assessment of the facts and the law, and a fair judgment. We will defend the President on the facts and on the law and on the constitutional principles that must guide your deliberations. Some have suggested that we fear to do so. We do not. I begin with a recitation of some of the events that have brought us here today. Although many of them may be familiar, they merit some discussion because they form the backdrop against which you must assess the evidence. I will then move to a discussion of the constitutional principles that we submit should guide your consideration of these matters, and finally to an overview of the allegations contained in the articles with a view towards focusing your attention on what we believe to be the principal legal and factual flaws in the case presented by the managers. My colleagues will follow tomorrow and the following day with a more detailed analysis of the facts underlying the articles. And at the end of our presentation, we will have demonstrated beyond any doubt that there is no basis on which the Senate can or should convict the President of any of the charges brought against him. And let me begin with a brief recital of the essential events in the Paula Jones litigation, which underlies so much of what we have been discussing for the last week. On May 6, 1994, Paula Jones sued President Clinton in the United States District Court for the Eastern District of Arkansas. She claimed that then-Governor Clinton had made in 1991 some unwelcome overture to her in an Arkansas hotel room, and that she suffered adverse employment consequences and was subsequently defamed. After the Supreme Court decided in May 1997 that civil litigation against the President could go forward while he was in office, the case was remanded to the District Court, and over the fall and the winter of 1997, the Jones lawyers deposed numerous witnesses, and inevitably, despite the strict protective order entered by Judge Wright and her continuing exhortation to counsel not to discuss any aspect of the case with the press, information flowed from those depositions into the public forum, clearly with only one purpose: to embarrass the President. Now, the principal focus of the discovery being conducted by the Jones lawyers during this period was not on the merits of their client's case. They devoted most of their time and their energy to attempts to pry into the personal life of the President. And Mr. Bennett, the President's counsel, objected to those efforts on the ground that they had no relevance to Ms. Jones's claims and were intended to do nothing other than advance the agendas of those who were supporting Ms. Jones's lawsuit. The Jones lawyers, however, pursued their efforts to inquire into the President's relations with other women, and on December 11, 1997, Judge Wright issued an order allowing questioning regarding only, quote, any individuals with whom the President had sexual relations or proposed or sought to have sexual relations and who were, during the relevant time frame, state or federal employees. Then on December 5th, 1997, the Jones lawyers placed on their witness list the name of Monica Lewinsky. And on December 19th, she was served with a subpoena for a deposition to be scheduled in January. Consistent with rulings issued by Judge Wright in connection with the Jones lawyers' efforts to secure the testimony of a number of other women. Some had sought to avoid testifying by submitting affidavits to the effect that they had no knowledge relevant to Ms. Jones's lawsuit, or that they otherwise did not meet the tests that Judge Wright had established before permitting this invasive discovery to go forward. On January 7th, 1998, Ms. Lewinsky did execute such an affidavit, and her lawyer provided copies to the lawyers for Ms. Jones and for the President on January 15th. The Jones lawyers deposed the President on January 17th, 1998. They began the deposition by proffering to him a multi-paragraph definition of the term sexual relations that they intended to use in questioning him. And there followed an extended debate among counsel and the court concerning the propriety and the clarity of that definition. Mr. Bennett objected to its use, arguing that it was unclear, that it would encompass conduct wholly irrelevant to the case, and that it was unfair to require the President to apply a definition that he had never seen before to each question he was asked. Indeed, Mr. Bennett urged the lawyers for Ms. Jones to ask the President specific questions about his conduct, but they declined to do so. Now, Judge Wright acknowledged the overbreadth of the definition, but she ultimately determined that the Jones lawyers could use a heavily edited version of the definition that left in place only the 2 lines of paragraph 1, with which you are already familiar. Immediately after this extended legal skirmish, the Jones lawyers began asking about Monica Lewinsky. Mr. Bennett objected, questioning whether counsel had a legitimate basis for their inquiry in light of Ms. Lewinsky's affidavit denying any relationship with the President. And Judge Wright overruled that objection and permitted the Jones lawyers to pursue their inquiry. 4 days later, the independent counsel's investigation became a public matter. And on January 29th, responding to a request by the independent counsel to bar further inquiry relating to Ms. Lewinsky, Judge Wright ruled that evidence relating to her relationship with the President would be excluded from the trial. She reaffirmed this ruling on March 9th, stating that the evidence was not, quote, essential to the core issues in this case of whether plaintiff herself was the victim of sexual harassment, hostile work environment, or intentional infliction of emotional distress. On April 1st, 1998, Judge Wright apologize for the logistical problems, but why don't I just hold it? On April 1st, 1998, Judge Wright granted summary judgment in favor of President Clinton, dismissing the Jones suit in its entirety. She ruled that no evidence that Ms. Jones had offered or that her lawyers had discovered made out any viable claim of sexual harassment or intentional infliction of emotional distress. Importantly, Judge Wright ruled that evidence of any pattern or practice of comparable conduct by the President was not important to the case. I want to take just a moment to read the relevant portion of Judge Wright's opinion, not to demean in any sense plaintiffs with claims of sexual harassment or to suggest that we must be other than vigilant to protect the rights of all citizens, but simply to bring into slightly sharper focus the role that the President's deposition played in the real Jones litigation. Judge Wright wrote, "Whatever relevance such evidence may have to prove other elements of plaintiff's case, it does not have anything to do with the issues presented by the President's and Ferguson's motions for summary judgment, i.e. whether plaintiff herself was the victim of alleged quid pro quo or hostile work environment sexual harassment, whether the President and Ferguson conspired to deprive her of her civil rights, or whether she suffered emotional distress so severe in nature that no reasonable person could be expected to endure it.